What is up, everybody? So we're continuing to go back and have a look at what was being printed in the press at the time of Steven Avery and Brendan Dassey's arrest and what was being printed at their time their trial was going on. This article, we're going all the way back now to June 17th, 2006, and it is from the Madison, Wisconsin State Journal. It states, dismissal of Avery case asked. Lawyer says publicity has damaged his right to a fair trial. This has come up a few times in these articles. A whirlwind of publicity over murder and kidnapping charges against Steven Avery has damaged his right to a fair trial so much that the counts should be dismissed, according to his attorney. Dean Strang filed a batch of pretrial motions Friday, the last day to submit them before the Manitowoc County Circuit Court Judge Patrick Willis considers them at the July 5th hearing. Now, this of course would be July 5th, 2006. Strang keyed heavily on publicity throughout the motions, contending authorities' comments during multiple news conferences, just like the ones Ken Kratz gave, turned potential jurors against his client. That's exactly what happened, forcing the judge to either dismiss all but one of the charges, delay his trial, or move the proceedings out of Manitowoc County. He also argued statements Avery made to reporters who interviewed him face-to-face in jail should be barred from evidence. Calumet County District Attorney Ken Kratz, who is serving as special prosecutor in the case, didn't return a message to the Associated Press left at his office on Friday. This next article is from June 27th, 2006, and it is also from the Madison, Wisconsin State Journal. The evidence in the Halbach murder case collected illegally, lawyer says. Evidence that interrogators collected at the trailer, home, and garage of Steven Avery should not be allowed when he goes on trial for the rape and murder of a photographer, a defense lawyer says. Attorney Jerome Buting claims in a motion that multiple searches were done even though only one search warrant was obtained, and he also contends the initial warrant was obtained illegally. Indeed, all the indications are that they simply acted as if the original warrant allowed them to come and go into Steven Avery's trailer and garage at will. Buting writes in the motion filed in the Manitowoc County Circuit Court, it did not. He cites case law as showing there should have been a warrant for each search. Jerry Buting says a search warrant wasn't obtained but should have been before volunteers were allowed to search for Teresa Halbach's vehicle in the Avery Auto Salvage lot, where it was found partially hidden. According to Buting's motion, the information supporting the initial search warrant request was obtained after an investigator illegally went on the Avery property to verify what volunteers found. A relative of Teresa Halbach testified at a preliminary hearing that she called the Calumet County Sheriff's Department to report finding a vehicle similar to Teresa Halbach's in the Avery salvage lot. She said a brother of Steven Avery's had given volunteers permission to go in the lot. An investigator confirmed that the vehicle was Teresa Halbach's and used the information in seeking a search warrant, Buting said. Whatever an officer finds during an unlawful entry cannot be used later to support probable cause before a search warrant magistrate. Now they searched Steven Avery's trailer something like 8 times, and Jerry Buting here was stating that they would have needed or should have needed an individual search warrant for each one of those searches. Instead, they only ever had the one, which they used as a way to go back and search it over and over and over again, but that shouldn't have been allowed. That is why he was looking at getting the evidence tossed that was found during those searches. This one is from the Madison, Wisconsin State Journal as well, and is from July 29th, 2006. Lawyers argue evidence issue in Steven Avery case. The details of how evidence was planted against Steven Avery are not needed if his attorneys allege any wrongdoing by the authorities, Avery lawyer says. In a written response to a sealed motion filed by Special Prosecutor Ken Kratz on June 15, 2006, Jerome Buting, an attorney for Avery, says the defense does not need to specify who planted the evidence or what evidence was planted. Such a rule would impose an impossible burden when the police are suspected of wrongdoing because they are in control not only of the physical evidence itself, but the record-keeping process designed to limit the record access to evidence and which could therefore be manipulated without leaving any record of tampering. According to filings, Ken Kratz claims Avery must specifically identify who may have planted the evidence if that defense is being used. Buting disagrees. Avery has no burden to prove his innocence in the case, Buting said. Neither must he prove that evidence was planted by a particular known individual, as the state argues. So they're already talking about, now this is June 29, 2006, they are already talking about evidence tampering, talking about how this stuff shouldn't be allowed as evidence in the court. Ken Kratz stating that they must say who specifically planted the evidence, but according to Jerome Buting, that's not something they had to do. They just had to prove that evidence was planted. They didn't have to say who planted it, just that it was there and that it was done. Those are the articles we are going to cover today. I'll be back soon with some new ones, but what do you think? What do you think of Jerry Buting's claims that a search warrant should have been issued for each individual search? And what do you think of him stating that they didn't have to specify who planted the evidence, just that it was planted? Let me know what you think. Leave some comments below. I hope you're having a good day, and I will see you again soon.